as I said, as I began by saying that in secular India, you cannot have a communal law, viewers. You cannot have a law that only militates against overwhelmingly the claims of one community. And how can, therefore, this inequality be secular? Of course, Dr. Swami says that the exemption must be applied to 2 more temples. There are others, of course, who believe that no, there should be no such stipulation that Hindus should be able to reclaim from their civilizational oppressors all their fundamental temples or other monuments, etc., that they believe are integral to their faith. Now, that's a larger argument, and I'm happy to indulge our panelists tonight, and let's open this up in that. But let me first begin by asking a question of Lokesh Jindal, leader of the Congress party here, who is with us. Mr. Jindal, how could the Congress in 1991 have passed or contemplated a law that overwhelmingly denies Hindus the right to reclaim their places of worship? And how did you propose that this particular law is a secular one when it differentiates, when it militates against the basic rights that are guaranteed by the Constitution, fundamental rights? And you know, right after that, notifications were issued barring Hindus who had been going and praying at the Gyanvapi Mosque and the Kashi site there for centuries altogether. What was the Congress's problem with the community?
Good evening, Rahul. When we talk about the Constituent Assembly, which was framing the Constitution, at that point of time, a major question emerged as to what shall be the nature of the Constitution that shall govern this entire country. At that point of time, almost all the lawmakers, they agreed that in order to have a secular form of Constitution, it is important to have positive safeguards given to the minorities which are vulnerable, because in a democracy, there could be the rule of the majoritarian. Subsequently, the Article 25 till Article 30, it implicitly aimed at creating a secular fabric to the country, to the nation, so that the rights of the minorities, they could be safeguarded, along with the majorities, they also enjoying the rights. The point is, Rahul, we cannot expect one community to enjoy their rights, thereby trampling over the rights of the others. However, your argument is that the Places of Worship Act 1991, it gives rights to the Muslims and it takes away the rights of the Hindus. That's what you state. But please understand, Hindus and Muslims, they are not equal in this country. I mean, Muslims, they are numerically inferior. They only constitute about 18% of the total population. And moreover, the Hindus, they are majoritarian. I mean, on all bases, social, economic, cultural front, they are at a relative advantage over this community. So I would state over here that the positive discrimination that has been the policy of the state, it must be respected, and the secular fabric of the nation must be preserved.
Okay, let me bring in Sai Deepak.
91 was introduced.
Let me bring in Sai Deepak on that point. He says the secular fabric, and I just want you, Mr. Sai Deepak, to bear with me. I'm reading out what Mani Shankar Iyer, in the course of the debate, had said in 1991 on the floor of the Lok Sabha. He said, when I come across a temple and a mosque together, then I feel that this is a secular country. I will request you, please listen. You too will get a chance to speak. Let me speak that I believe that this is a secular country and that spirit of secularism is being upheld. How do you respond to the charge? And of course, to what Lokesh Jindal is saying is that those like you, like Dr. Swami, to different degrees, who want to overturn this 1991 Act are actually acting against the spirit of brotherhood, etc.
So, Rahulji, so just a few clarifications. I am not appearing in this matter in my personal capacity as a petitioner, although I may have my own views on this particular legislation, which are fairly clear and categorical and firm.
Yes.
I represent the Kashi royal family with respect to the Rabia Mosque, which was demolished by, the Razia Mosque, which was demolished by Razia Sultana, so to speak. That is the specific issue that we have raised there. Now, Before I proceed to respond to Mr. Jindal's position, please note that while I respect Dr. Swami's erudition as well as his sagacity, I have very clear disagreements with Dr. Swami on the position that he has taken with respect to only exceptions being made for Kashi and Mathura on par with or at par with Ram Janmabhoomi. Because in my opinion, that is not legally possible, because it's not possible for you to ask the court to read into a legislation extra exceptions which the legislature did not intend. To say that there are certain other exceptions, that too ought to have been included. That's point number one. Point number two, none of us can make concessions on behalf of the actual title holders with respect to each of the properties, because like Ram Janmabhoomi, principle of title suits will apply to each of these places. It is for the right owners to make those concessions. Third parties cannot make these concessions. So that's not possible. Now, whatever anybody may have decided at some point, that cannot be given the scope or let's say the status of a legal agreement, because nobody has entered into any such agreement in representative capacity on behalf of Hindus. Nobody has given them anybody the power of attorney as far as this issue is concerned. This is a legal statement. I'm not making a sarcastic or a rhetorical statement. Okay. Three. Now, whether this amounts to a hot-headed position or not, I cannot comment on that simply because I'm representing a particular party here. And I believe that each party has a legitimate right to seek the repatriation of its own property, and that wouldn't amount to hot-headedness. That is my limited submission. Now, on Mr. Jindal's point, please note, I think the word secularism is perhaps the most abused and, let's say, disabused word in the entire, let's say, English dictionary as far as the Indian discourse is concerned. Secularism, when stripped to its most basic fundamentals and its conceptual doctrine, stands for what? That the state shall not take a specific or adopt a specific religious position, will not have a religious character of its own, and therefore it shall stand equidistant from all religious identities. Now, in this case, therefore, what are we saying? Please do not stand in the way of the legal remedy of one particular community to approach the court through the, let's say, through the option of Article 32 or through suits, because when the state actively stands in the way of judicial remedies, it amounts to curbing that specific fundamental right. And Rahulji, since you have participated in several legal discussions as part of your debates, the right to approach the court for enforcement of fundamental right is itself a fundamental right. Okay? And therefore, when you use a legislation to stifle, snuff out, and completely abrogate that particular right, that is the state, the so-called secular state, taking an anti-secular and unsecular position which stands in the way of my religious rights to protect the usurper's rights. That is the textbook definition of being unsecular. So this majoritarian nonsense, this minoritarian nonsense, none of this has got anything to do with the definition of secularism. Like a Congress spokesperson, I understand, will have his fundamentals as far as secularism completely muddled. I have no doubts about it. No wonder we are where we are in terms of the legislation continuing to stand. Now, the point Dr. Swami made with respect to Mr. Tushar Mehta's submission is bang on the point, which is absolutely right. Because you see, as far as Ram Janmabhoomi judgment is concerned, one of the arguments that we have also raised and others have raised is that there was no occasion for the Supreme Court to deal with the Places of Worship Act in the context of Ram Janmabhoomi, because that specific dispute was excluded from the scope of the legislation. So why will you discuss the legislation? When you discuss something that has got no relevance to the issue at hand, it is known as obiter dicta, meaning thereby it has no binding value. But there is something else which most people missed out, which I actually pointed out during the course of my submissions today. The reference to the Places of Worship Act in the Ayodhya judgment of the Constitution bench is based on a completely erroneous reading of the three-judge bench of the Allahabad High Court. So whoever the author of the Ram Janmabhoomi judgment is, we still don't know, because no particular judge said that I signed it. It's been commonly signed. We still don't know who the author is. That's not relevant, of course. I'm just saying we don't know. Effectively said that Justice D.V. Sharma, who was a member of the three-judge bench of the Allahabad High Court, has referred to the Places of Worship Act, and therefore it falls upon us to take a look at that particular discussion. If you read Justice D.V. Sharma's judgment, and I've written a two-part piece on this in the New Indian Express and several other places immediately after the pronouncement of the verdict, Justice D.V. Sharma did not make a reference to the Places of Worship Act whatsoever. In fact, as part of his discussion on whether fundamental rights can be asserted by way of civil suits, he was extremely extracting a 1995 judgment of the three judgment of the Supreme Court, where there was a discussion on the Places of Worship Act. The Supreme Court mistakes this for a reference by Justice D.V. Sharma, makes that the pretext for a discussion of the Places of Worship Act, and then goes on to write 10 pages on how the Places of Worship Act effectively protects secularism, which happens to be the basic feature of the Constitution. Therefore, one of the submissions that was presented before the court today was that the Ayodhya verdict is factually incorrect insofar as its discussion on the Places of Worship Act is concerned, because apart from the fact that the act does not apply to Ayodhya, there was no occasion. It was completely based on an erroneous reading of the Allahabad High Court itself. So therefore, to answer Mr. Jindal's position, he may perhaps have slapped a few basics around in describing what is secularism. This legislation is the textbook definition of what is an anti-secular legislation, because it supports the right of one community over the other without giving sufficient reasons for the same.
Also, let me tell you, viewers, that even if the Supreme Court had decided to pronounce some sort of binding verdict on the Places of Worship Act, it couldn't have done so. It would have been in contravention of its own rulings, because in Director of Settlements, Andhra Pradesh and others versus M.R. Apparao and another on 20th March 2002, the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It is therefore an essential function of the court to interpret a legislation. The statement of the court on matters other than law, like facts, may have no binding force, as the facts of two cases may not be similar. But what is binding is the ratio of the decision and not any finding of fact. It is a principle found out upon a reading of a judgment as a whole in the light of the questions before the court that form the ratio, and not any particular word or sentence. To determine whether a decision has declared law, it cannot be said that be a law when a point is disposed of on concession, and what is binding is the principle underlying a decision. A judgment of the court has to be read in the context of the question which arose for consideration in the case in which the judgment was delivered. So very specifically, the Supreme Court itself has said that a judgment of the court has only to be read in the context of questions which arose for consideration. In the Ram Janmabhoomi issue, there were a few specific questions that arose for consideration, and they only had to do with the Ram Janmabhoomi, not anything to do with any other matter, and therefore, only the court can only rule on those specific points, on no other. Now, let's open this up, because we've established, perhaps viewers, that a grave inequality persists here. As J. Sai Deepak has told us, what kind of state denies any person the right to approach the court? Fundamentally. So let me bring in another lawyer, Syed Rizwan Ahmed, and I also want to bring in Danesh Qureshi. Mr. Ahmed, I want to ask you, why would the Congress come up with a law that denies Hindus overwhelmingly? Because let's face it, it was Hindu properties, Hindu places of worship that were majorly affected. Why would, therefore, the Congress contemplate bringing in a law that denies Hindus principally the right to approach the court in the first place? Mr. Ahmed.
Thank you so much. Jai Hind, Vande Mataram. Yeah, see, more than denying Hindus their right to approach the court, I think it is more a matter of appeasement of Muslims. Rather than discrimination against Hindus, I think it was an appeasement for the Muslims, number one. Number two, we were talking about secularism. What I feel, I'm not a constitutional expert, that secularism and minority, both the words cannot go hand in hand in the same constitution. This I have been reiterating from the last 5 years. It is a constitutional oxymoron. When we had equal law for all in the constitution without using the word secular, and we were treating all the citizens equally, and the government did not have an official religion, we should have waited to see how things transpire and how things unfold, And if there would have been circumstances or occasion or ground to safeguard the minority in this Hindu majority country, then we should have made this constitution secular, or else both the things cannot go together. If you need the word minority, you should have a religious state. India could have been a Hindu Rashtra, which was a pluralistic society safeguarding the minorities. Then it would have been correct as far as I think. Now what Mr. Sai said, that he is not on the same page with Dr. Sahab, I also don't agree when he said that we will have these three issues, three temples. You know, Sanatan Dharma is a very large belief, a very vast belief. You cannot say that all the main gods existed in this part of the country, which is now present day Uttar Pradesh. I was talking to a guy yesterday, he said we are not celebrating much Holi or even Diwali back down south. So the point is, Muslims, they captured and conquered Pan-India. They violated Pan-India. They ransacked Pan-India. So how can Mr. Subramaniam Swamy as an individual say that all other temples are irrelevant, and he went to say that the government should come out very hard against those people who are not seeking relief other way. See, anybody can say this temple in Karnataka is important for me more than Ram Janmabhoomi and more than Krishna Janmabhoomi.
No, Ahmed Saab, Rizwan Saab, I think what he was saying is that the government should define its position in hard terms. That's what he meant. Not take action against those people who are coming to court. I think that's what he meant. He said that the government should come up with a very firm position on this.
But how can...
Yeah. Anyhow, that's a different matter. I understand. That's a different matter. My point is, do you believe that the Supreme Court today, the Supreme Court today has taken a leap forward in deciding upon this matter by getting the center into it, and should perhaps parties like the Congress, etc., now come out and support the granting or the petitions where the Hindu side are saying that, look, at least give us the right to approach the courts, if nothing else. Rizwan Saab.
Rahul, my humble submission is, though I am not a Supreme Court lawyer, but with prudence and as a lawyer in Lucknow, I can tell you one thing: it is a very precarious situation which perplexes me. See, what I feel, and note the date today, I really do not feel that Act of 1991 will be absolutely abrogated.
Okay.
I really don't think so, that the government of the Supreme Court will open the gates absolutely for suppose 2,000 petitions to come pan-India. Number two, it is very difficult for Supreme Court and the government to define that we are confining this act, limiting this act to 3, 4 or 5 places. So I really cannot put my submission in that what will the Supreme Court do. Yeah.
Let's not presage that. I'll come to Sai Deepak at the end on looking at perhaps what the center can do now. But let me very quickly go across to political analyst Danesh Qureshi, who's a sympathizer of also the MIM. Mr. Qureshi, you have a situation here where one particular community is shackled by the law, which was passed clearly. And let me tell you, the father of Asaduddin Owaisi, Sultan Owaisi, came out and backed the Places of Worship Act. In the Lok Sabha, he gave a long speech just before the bill was introduced for vote. Now, why would you want to disenfranchise your Hindu brothers? Why would you want to do that? Why wouldn't you want them to at least, on the face of it, get justice? Not from you, but from history.
Rahul, first of all, I am 100% disagree with Mr. Subramaniam Swamy what he just said. is said to be excluded. One of the place, Mathura, and second in Kashi. First of all, we talk about the judgment on verdict on Ayodhya. What was the Supreme Court stated in that the Places of Worship Act will be the part of the basic structure of the Indian Constitution.
No, sir, please.
And after that, they started all things.
Danesh Saab, now you are again, one second. You are playing fast and loose with the facts.
Don't interrupt. Did anybody has clarified did anybody has defined the place where God Ram was born? No, nobody. And once again, the Krishna Janmabhoomi is being claimed. Is being going to claim. What do you want? They want this time 2 places to be excluded from the Places of Worship Act. After this 2 places, they will come up. We need 5 more places or 100 more places to be excluded. Then, if we want to exclude time by time or series by sequence, then what is the meaning of this act? We have to understand that. At that moment when Supreme Court has given verdict on the Ayodhya, what was the Supreme Court was stated that we don't want that such types of matter should be entertained by the
Qureshi
Supreme
Saab,
Court.
I don't think you've read the judgment. First of all, you are completely massacring what the judgment said. No, please don't do that. First of all. Secondly, AIMM came out and said at that time that the Supreme Court's judgment on Ayodhya is flawed. That the Supreme Court, and this was the implication, that the Supreme Court itself was, at some level or the other, forwarding or furthering the cause of a Hindu Rashtra. This is what was said. Now,
don't party that, Rahul, I want to ask you, did anybody have defined
you said it was faith over facts. No, one second, sir, please let me finish. It was faith over facts that the Supreme Court had put faith over facts. Now, let me ask you, sir, you are so dismissive of the Hindu faith.
Nobody is dismissive.
One second, sir. You just said, kisne dekha ki Ram kahan janam hue? You just said, who knows where Ram was born or Krishna was born? Sir, this is a matter of faith. You take your matters of faith so seriously that even if someone were to question them, a whole brigade of people jumps onto the streets and says, Sartan se juda, and all this.
You know that.
Rahul, I think that is not fair.
What did you accept that?
If another faith, if another belief system, if another belief system has certain.
Can the Supreme Court give the judgment on the faith beyond the facts?
Danesh Saab, please, that's not fair, because they went into the Supreme Court in the Ayodhya Ram Janmabhoomi case, went into sir, the title. They went into the title. You came out and deliberately obfuscated and suggested that the Supreme Court has saffronized.
Rahul, I want to reply from you. Once again, we will go on the basis of faith instead of fact.
Danesh Saab, titles will be examined.
What titles are we going to examine?
That is what has happened. Anyhow, one second. Okay, listen, sir, I understand. Sir, you are sounding like one of those supremacists where only your belief, your faith should be given. Should be given credence. Tomorrow you will say, and I think a large number of people do argue this point. One second. Danesh Saab, please. 1 second. Give me 30 seconds, please. It's not a question of law, sir. The law goes into the facts. They don't go into the realm of faith. Please understand.
And faith be
okay, one second. Sir, please. That's not fair. Don't disregard the faith and their beliefs. That is intolerance.
Nobody is disregarding that.
Of course you are. That is what exactly this particular law does.
Okay.
Let's be honest about it.
Bigger than
Sai Deepak. Okay, good. Sai Deepak, very quickly. First of all, this whole question of, you are being emotional, basing everything on faith and not facts, etc., number one. And number two, Sai Deepak, lastly, what do you think the center is inclined to do?
I think the center is perhaps playing safe at this point, is my honest opinion. Because this is the 3rd or the 4th time that the center was given a specific 2-week indulgence to file a response to all the petitions across the board. And you have to realize that it's not as if these petitions were filed a few weeks ago. Some of these petitions were filed early this year, sometime in March, April. Ever since, these petitions have been languishing. And the last date of hearing, time was sought on behalf of the center. But I don't wish to comment on that beyond that, except to say that I think the center understands that this legislation cannot be protected And when the union chooses not to file a counter to a petition challenging the vires of that particular legislation or the constitutionality of the legislation, then I would say res ipsa loquitur, the facts speak for themselves. That is the point that I would want to make. Just one more submission, perhaps you may want to consider this, just to perhaps add to Rizwan Bhai's point and to perhaps build on what Dr. Swami said, which I disagree with. See, some of the temples whose reclamation is being sought as part of these petitions, including the petition in which I represent, you have to realize that some of these petitions may not be birthplaces of deities, but they have been mentioned in scripture. Not just in so-called local scripture, but also as part of, let's say, the Vedas, the Puranas, so on and so forth. Now, how can we say that some of those places have lesser importance compared to those places which are celebrated as birthplaces or Janmabhoomis?
Sure.
Right? And therefore, I don't think this is a distinction that is worth striking.
Yes.
Because I, as someone who comes from the south, I may believe that Chidambaram is more important than some other place. Okay? Just as Kamakhya would be more important for people from Assam compared to any other place in the south or the north. Kshir Bhavani may be more important for people in Kashmir than any other place. Amarnath may be more important for people in Kashmir than any other place, for Kashmiri Shaivites. Therefore, considering that the Hindu Sanatana Dharma is effectively an agglomeration of sampradayas and traditions across the country, it is the right of each of these sampradayas to reclaim what belongs to them and what they hold dear. It is for nobody else to actually say, you can't ask for this in the name of peace. Because if it's a question of peace, then we're expected to give up everything. Then what is the difference between that position and the opposite side's position? That can't be the argument. If you want to make an exception for one, make an exception for everything. Otherwise, that distinction is the textbook definition of arbitrariness or unreasonableness.
Well, viewers, let me tell you, we are at a point of inflection. The Supreme Court is going to become the center of a massive debate that will unfold by the end of the month. 15 days the center has now to respond. And they've asked specifically for these 15 days. So I'm sure right now in the center itself, in government, in high government, there are many conversations going on about what position to take. And one just sincerely hopes that they take a position which is enlightened, which actually respects not the Congress version of secularism, but perhaps what we all believe is constitutional secularism. I just hope that that is where we are going to be in the next 15 days. But viewers,